Get ready for the dictation. Start. This was followed by another complaint filed with the collector Surat on 23/1/2012 against 6 named persons, seeking therein the prosecution of those persons for having committed the alleged offences punishable under sections 34, 114, 120b, 420, 465, 468, 471 and 476 of the Indian Penal Code 1860, read with sections 3, 7 and 11 of the Scheduled Castes and Scheduled Tribes Act 1989. The complaint also set out the allegations with details alike the previous one with some new facts. Yet another third complaint was filed with the collector, District Disputes Redressal Forum, Surat, on 7/10/2013 by one of the complainants against 8 named persons, making more or less same allegations made in the first 2 complaints with more detailed facts, seeking to prosecute them for the commission of offences named in the earlier complaints. It is these 3 complaints which led to registration of the FIR on 6/6/2016 with Khatodara Police Station, Surat, giving rise to filing of several criminal applications, bail petitions, etc., one after the other at the instances of the named accused persons and others alleged to be involved in the cases. These cases were filed in the lower court, the high court and also in this court, one after the other during the last 4 years. The courts passed several orders with observations made therein. The present bunch of appeals arises out of the criminal applications filed by the named accused persons in the aforementioned three complaints under section 482 of the Code of Criminal Procedure 1973 in the Gujarat High Court, seeking therein a prayer to quash the aforementioned FIR. By impugned judgment dated 10/7/2017, the single judge of the High Court partly allowed the criminal applications and passed the following operative portion to the judgment contained in para 88, which reads as under. The first information report, so far as the offence punishable under sections 406, 420, 120b of the Indian Penal Code and the Atrocities Act is concerned, is quashed. The investigation as regards the allegations of creating the 2 bogus power of attorneys and erasing of 73 AA is concerned shall be completed by the Commissioner of Police, Surat, in accordance with law. The Commissioner is also directed to undertake the investigation as regards the persons who had approached the landowners and had obtained the thumb impressions on the complaints addressed to the Commissioner of Police, Surat. To put it in other words, I direct the Commissioner to undertake proper investigation as regards the allegations of blackmailing and extortion levelled against the particular persons. It is against this judgment both parties, that is, the complainants and the accused persons, have felt aggrieved and filed these appeals. So far as the accused persons are concerned, they have challenged that part of the order by which the High Court has dismissed their criminal applications and declined to quash the FIR in relation to some offences alleged against them. According to the accused persons, the High Court should have quashed the entire FIR instead of quashing part of it. So far as the complainants are concerned, they have challenged that part of the judgment by which the High Court has quashed the FIR in relation to some offences. According to the complainants, the High Court should have upheld the entire FIR as it being legal and proper. It should have been given full effect in accordance with law against the accused persons. This is how the entire controversy is now again raised before this court in this bunch of appeals by way of special leave at the instance of the complainants and accused persons in their respective appeals. Stop.